Alright, Section 18, preemption, general, and with itself reinforcement except for the otherwise provided in C, D, E, and F, and G, with the subject of the paragraph 2, the state and political division, state may establish the continuing enforcement of the following development information, state of the action required with the development information, chemical stuff of the category, some of the responsible likely to produce the same information required in section 4, 5, and 6, and the rule propagated administrative consent of the agreement into the administrative of the and 3, the an order issued by the administrator be a chemical substance found with the not present with the unreasonable risk and the restricted the state with the criminal penalty administrative the action prohibited, otherwise restricted the manufacture, process, the distribution, commerce, UV of chemical substance for UV determination. Described in section 6.1 is made consistent with the scope of the risk evaluation. Section 6b 4d, for which the final rule is propagated on 6a with the effect of the date of the rules issued. 6a with the chemical substance consistent with the scope of the risk evaluation under section 6.4b 4d. Significant new use. A statute demonstrated that required the notification of the chemical substance administrator specified the significant new use for which the administrator have the required notification pursuant to the rule promulgated under section 5. Effective the date of the preemption, with the subjection of the federal and preemption of the statute of the administrator of the connection of the applicable the chemical substance shall not occur until the effective date of the applicable action described in the paragraph B paragraph 1 by administration. Alright, B. New statute criminal penalties administrative action creating prohibitions of the restrictions general except for the provided in paragraph C, D, and E, and F, and G at the beginning of the date of the administrative state defines the scope and risk of evaluation of the chemical substance under section 6B 4D, and of the date of the deadline established pursuant to section 6B 4G for completion of risk evaluation expired with the date of the administrative published with the risk evaluation under 6B 4C, whichever the earlier no state of the political subdivision may establish a statute criminal penalties administrative action is prohibited otherwise for restriction manufacture processing distributing and commerce in the use of the chemical substance within the high priority substance designated under 6B1B1. Effective subsection does not require the restricted authority of the state with the public subdivision state with continuing enforcement statute and enacted criminal penalty and as for the administrative action prior to the date of which the administrator defines the published scope of the risk evaluation under 6B4D. Scope of the preemption, final preemption under the subsection A and B of the statute, criminal penalties, administrative actions applicable to specific chemical substance that is applied only to, with respect to subsection 1A with the chemical or substance of the category chemical substance subject to the rule of the order consistent agreements under section 4, 5, and 6 with respect with the subsection B with the hazard exposure risk use condition with the chemical substance includes the scope of the risk evaluation pursuant to 6B4D with the respect with the section A1B with the hazard exposure risk due to the use of the condition with the chemical substance include the final action administrative taken in section 6A and 611 with respect to the A14C with the use of this chemical substance administrative has specified the significant use the administrator have the required notification pursuant to the rule promulgated in section 5. Exemption, no preemptions that use of the administrative action. In general, nothing in the act, but they have not amending the made of the Franklin R. Lutenberg Chemical to the Act of 21st century, nor any rule of state of the true standard performance risk evaluation scientific assessment implemented and pursuant to the act with the effect of the right of the statute of the public state division and top of the enforcing any rule standard performance of the risk evaluation scientific assessment any other protection or public health of the environment that is adopted authorized by the authority of any other federal law with the adopted Senate is satisfied with the obtainment of the authorization approved with any of the federal law with the elements of the reporting and monitoring other information obligation chemical substance otherwise required by the administrator under the law required under the applicable law. The adopted pursuant with the authority of the law with the student public subdivision with the state related with the water quality, air quality, waste treatment, and disposal except to the extent of the action put with the restriction of the manufacture process, the distribution, and the commerce for the use of the chemical substance. 2AA, the address of the SAML hazard aspects, exposures, and with respect to the condition of the UV, they include with the scope of the risk evaluation pursuant with the paragraph, section 6B4D, with the ruling consistent with the action of the administrator of the BB would call for the violation applicable to the action administrator under section 5 and 6, or 4, subject to the subparagraph B with identical with the requirements of prescribed in the administrative identical requirements in general. The penalties of the other sanctions applicably under law of the state of the public subdivision of the state of the event, no compliance identical state and requirement of no more than stringent than the penalty of the other sanction available to the administrator under section 16 of this act. Penalties in the case of the identical requirement of the state of the public subdivision state of the non-asset of the politics and penalty specific violation administrative that has been adequately penalty under section 16. The state of the public subdivision has set of the penalty of the specific violation administrative may set of the penalty of the violation amount that would cause total penalties to set of the violation state political subdivision state of the administrative combined with the exceed of the maximum amount with the may be a set of the violation of the administrative section 16. Alright, applicability certain rules and standard prior rules in order nothing in the section with the contributed amount for the preemptive effect for the section and effect of the day of the Franklin R. Lutenberg Chemical Safety of the 21st century with any of the rule other promulgated issue with the act of the prior to the effects of the date. B. Certain chemical substance mixture with respect to the chemical substance mixture with the rule are promulgated issue with the section 6 prior with any either section 6 prior with effective date of the Franklin R. Lutenberg Chemical Act of the 21st century with respect to the manufacturing, processing, distribution, commerce, use, the disposal, chemicals, some of the mixture with nothing and such over the contributed amount of the preemption of the action and the effect of the make prior to enactment of the Franklin R. Lutenberg Chemical Safety Act of the 21st century of any of the rule, order, and the promulgated that issued respect to the chemical over the mixture of the act with the section 8 section 6 of the effect of the date of the later with the order with the respect of the chemicals over the mixture or containing chemicals of the files designation technical chemical substances the high priority substances of the 6B1B1 identification chemical substances 6B2A with the sexual extraction of the chemical substance with the risk of violation 6B4A242. Alright, your preservation of the certain laws in general, nothing acts as the object of the subjection G of the section construed as preempts otherwise effective the authority of the state and public subdivision state of the continuing enforcement action requirement imposed other requirement on acted relating to the specific chemical substance of the before act April 22nd, 2016, the authority of the law and subject state political subdivision state of the prohibit the other restrict the manufacture processing distribution, commerce, or use for the disposal of chemical substances. Construed within the preamble the otherwise any of the action taken in pursuant of the state law with the effect of the August 31st, 2003. Effect of the subsection does not affect the modify, alert, or alter relationship with the federal law and laws of state and political subdivision state pursuant to any of the federal law. Alright, F, waivers. Discretionary exemption. Even the application of the state of the public subdivision, state administrative rules, exemption of the subsection of the end of the conditions may be prescribed with the rule of the state true with the criminal penalty, administrative action, state political subdivision of the state related to the effect of the exposure of chemicals over the other condition of the administrative determines A, the compelling conditions warrant granting of the waiver to protect the human health and the environment, complying with the proposed requirements of the state public subdivision state would not unduly burden the interstate with commerce, the manufacture, processing, distribution, and commerce use of the chemical substance. Complying with the proposed requirement of the state public subdivision the state with the cover the violation of applicable federal law, rule, or order. The judgment administrative proposed requirement of the state of the public subdivision state with the design address the risk of the chemical substance under condition of use identified with the consisting of the best available to see with the using supporting study that conducted in accordance with the base of the sound and objective state scientific practice. 3, the based on weight scientific evidence. The 2 required exemption. Use the application of the state of the public subdivision state of the administrative step of the subsection B the state administrative action of the state public subdivision state shall relate the effect of the exposure of the chemical substance of the condition of the administrative determines that the complying with the proposed requirement of the state of the public subdivisions will not unduly burden the interstate commerce, the manufacture process, the distribution, commerce, use of the chemical substance. 2. Complying with the proposed requirement of the state public division state will not and violate any probable federal law, rule, or order. State of the public subdivision state has concerned the chemical substance of the use of the chemical substance based within the peer-reviewed science. No later than the administrator 18 months after the date of the administrator has initiated the prioritization, use and process of the chemical substance under the rule promulgated under 6B1A. Date of the administrator publishes the scope of the risk evaluation chemical substance under 6B4D, which if the state of the political subdivision state of the inactive of the state of the proposed finalized as an administrative action, intent with the prohibit the otherwise restrict the manufacture, process of the distribution, commerce, over the use of the chemical substance. 3. The determination of the waiver of the request the duty of the administrative grant that they can deny by the waiver application non-intelligible shall be exercised no later than 180 days after the date of which the application on paragraph 1B is submitted, no later than 110 days after which an application on paragraph 2 is submitted. 4. Failure to make determination of the administrator fails to make determination of 3B during the 110-day period before the date of which the administrator applicable paragraph 2 is submitted with the statute of the administrative action of the public division of the state with the subject of the application not be considered to be existing statute administrative action for purposes of subsection B by reason of failure of administrator not to be taken determination. Notice of the commitment, notice and comment. Acceptance in case of them approved with the paragraph 9 to application state and political subdivision of the state under this subsection shall subject the public notice and comment. Final agency action, the decision administrator shall on the application state and public subdivision shall be A. Consider final agency action, B. Judicial review, duration waiver the waiver granted with paragraph 2 with approved of the waiver. Paragraph 9 shall remain in effect until the time of the administrative purchase through evaluation under section 6B. Judicial review and waiver no later than 60 days after the date of the administrator shall determine whether the application state public subdivision state under paragraph B1 and 2, person may public petition judicial review the United States Court and Appeals for the District of Columbia Court, which shall have the exclusive jurisdiction over other determination approval. Alright, automatic approval of the administrator fails to meet the deadline established in paragraph 3B with the application state with the public division state with under paragraph 2 with automatically approved with the effect of the day of the 10 days after the deadline requirements of the amendment state with the paragraph 6 with the approval of the written waiver applicable. Paragraph A with the waiver to meet the failure to deadline of 3B shall not be considered final agency action subject to the judicial review, public notice, and the comment. Stating no preemption of the common law, statute, or cause of the action with the civil relief of the criminal conduct. In general, nothing in an act within or any amendment made with the Franklin R. Lutenberg Chemical Safety Act of the 21st century, any standard rule requirement, standard performance risk evaluation, scientific assessment implemented pursuant to this act shall be considered construed, preempted, displaced, supplemented any state, federal, common law regulators, any state, federal statute creating a remedy of civil relief, including those with civil damage and penalty criminal conduct. B. Clarifying no preemptions when notwithstanding any of the provisions of action, nothing in the act within the amendment of the Franklin Lutenberg Chemical Safety 21st Century Act shall be preempted, precluding the cause of the action, personal injury, wrongful death, preempted property damage for the injury based on negligence, liability, product liability, failure to warn, any other legal theory, eligible legal liability, any other statute, law, maritime, federal, common law, and statutory theory. R2. No effect of the other private remedies in general, nothing in the act nor amendment made with the Franklin R. Lutenberg Chemical Safety 21st Act of the Century Act, any rules, regulation, requirements, and risk evaluation, scientific amendments, or orders issued pursuant to the act shall be interpreted as either blatant defendant's favor or dispositive in any conceivable action. Alright, authority of the courts act does not affect the authority of any of the courts to make the determination in any of their educatory and proceeding other special state and federal laws with respect to the mission into evidence any of the use of acts or other regulation requirements, standards, performance risk evaluations, scientific assessments, and orders issued pursuant to the act. 1619 judicial review, and then we're gonna cut the tape right there at section 19.